Ready? Start. Aggrieved against judgment and decree passed by the trial court, defendant number 2 filed an appeal before the lower appellate court. Stop. However, the plaintiff in the suit had not filed any appeal against the dismissal of his suit. Stop. Therefore, the appeal before the lower appellate court was against allowing the counterclaim of defendant number 1 against defendant number 2. Stop. The lower appellate court allowed the appeal filed by defendant number 2 and set aside the judgment and decree passed by the trial court qua defendant number 2. Stop. One of the grounds recorded for setting aside the judgment and decree qua defendant number 2 is that the counterclaim could not have been filed against him, he being a co-defendant, and the claim against him being an independent claim having no relation with the claim raised by the plaintiff in the suit. Stop. However, liberty was granted to defendant number 1 to seek her remedy against defendant number 2 by filing a separate suit. Stop. Besides this, a further direction was also issued against defendant number 1 and she was directed to restore the original position of the open yard which was claimed to be the suit property in the case. Stop. Challenging this judgment, defendant number 1 has filed the present appeal. Stop. Learned counsel for the appellant submits that the lower appellate court has wrongly held that the appellant could not have filed a counterclaim against her co-defendant. Stop. He has submitted that the counterclaim against a co-defendant is very much maintainable. Stop. It is his submission that the provision of counterclaim has been made to reduce the litigation and to ensure that the dispute is decided in one go. Stop para. The next contention of learned counsel for the appellant is that even if the lower appellate court was to set aside the judgment and decree of the trial court in her counterclaim, then also the lower appellate court has erred and issuing further direction to her to restore the original position of the common yard. Stop. It is submitted by learned counsel for the appellant that this was not even the claim of the appellant before the lower appellate court. Stop. Hence, the relief granted was even beyond the claim made by defendant number 2 before the lower appellate court and the trial court in the suit. Stop. Hence, it is submitted by him that the judgment and decree passed by the trial court be restored. Stop. Still further, it was submitted by him that lower appellate court has rightly recorded that counterclaim was filed behind the back of defendant number 2 and he was not even given any notice regarding the counterclaim filed against him. Stop. Defendant number 2 did not even have the knowledge of the counterclaim. Stop.